Michael, how are you? Sorry we're running behind. Do you know how to do the thing, or do you guys have microphones? You're going to need one, Bob. I mean, Brian, you're going to need, grab one of those off the table. Yeah. Let me start it for you there. I didn't know if you knew how to do it or if you wanted me to do it. Hold on a minute. Got a little nuts. I gotta find the file too. I have all my trial stuff up here. I don't think she's logged on yet. You may want to check with her, because usually it's up in the corner. Oh, here she is. Here she is.
Okay, great.
Okay, so you guys need to turn your microphone over, and there's a power thing on the bottom. Press that until that light gets green. Ma'am, can you hear me? So I can't hear you. Look down there where your hand is, Kevin.
Yeah.
See, there's a little microphone. See if the X is on it. Can you hear me, ma'am? Can she hear me or not?
Sure.
Hello?
Okay, I can hear you. Can you hear me?
I can. Now I can.
Now you can. All right, have a seat, please. Give me one. I got to film this. Okay. Ready. I'm ready. All right. All right, we're here in case numbers 677-866 and 680-880. Those are two cases in which I'm going to be doing sentencing on. State of Ohio versus Dalontay Edmond-Geiger. He is present in court today with his attorney, Mr. Brian Radigan, and Kevin Brigman is here on behalf of the state of Ohio. The record should reflect that on April 12, 2023, Mr. Edmond-Geiger pled guilty in case number 677-866 to receiving stolen property, motor vehicle, count 1, a felony of the 4th degree. Before I had the opportunity to sentence him in that matter, he picked up 680-880, and he pled guilty in that case on October 30th, 2023 to count 2 as amended felonious assault with deletion of all firearm specifications. Count 4 as amended, kidnapping with the deletion of all firearm specifications. Count 5, tampering with evidence as amended, with the deletion of the firearm specifications. And count 6, having a weapon under a disability as indicted. Counts 1 and 3 were nollie. At the time of the plea, I did order a pre-sentence report. I also ordered a mitigation evaluation. I've received both of those reports. I also have a sentencing memorandum that was provided to me by Mr. Bringman from the state of Ohio. I've had an opportunity to review that as well. I also have in front of me a status report for probation case number 677866 that was and 650393. Those were for low-level felonies, felony of the 4th degree, forging identification cards, a felony of the 5th degree, and attempted grand theft, felony of the 5th degree. So I'm going to address the probation violations as I address the sentencing in the 2 new cases. Mr. Radigan, have you been provided with a copy of the status report?
Yes, Your Honor.
All right. Did you read it?
I did.
All right. Do you want to waive the presence of the probation officer?
Yes, Your Honor.
All right. So we'll go forward on that as we go forward on the other 2. All right. Have both of you received a copy of the pre-sentence report as well as the mitigation evaluation? Mr. Bringman, on behalf of the state of Ohio, did you receive it? Did you find it to be accurate to the best of your knowledge?
Yes, Your Honor.
All right. Same question to you, Mr.
Yes, Your
Radigan.
Honor. Thank you.
Okay. I also noticed that we do have the victim present in case number 680880. She is appearing remotely via Zoom, which is fine. Is it on the TV screen in front of them?
It is.
Okay, so the defendant, Mr. Dalontay Edmond-Geiger, has the ability to see that screen in front of him. I am prepared to go forward with sentencing. With regard to case number 677866, and then I would think with regard to 650393, I didn't sentence him in 677866, did I? Because they have it on the status report, but I thought he hadn't been sentenced in that. Let me look at it. My question for you, Mr. Bringman, is: are you in compliance with Marcy's law on all of these matters?
Yes, Your Honor, I believe so. 677866?
Yeah.
Okay.
So the status report for probation puts 677866, but I have on my pre-sentence investigation 677866.
Your Honor, I believe that he was sentenced in that case on April 20.
He was ordered for a post-sentence for the 677866 case. So that was included in the pre-sentence investigation as well, because the probation was unable to complete the post-sentence.
Okay, I understand what happened. All right, so he actually pled guilty and was sentenced in that case on 4/26/23. I get what you're saying. I ordered a post-sentence report, but because he picked up the new case before they completed the post-sentence report, they completed it with the pre-sentence report. I wish they would indicate that on the reports so that it looks like I hadn't sentenced him. Who else is trying to get in?
Thank you, Your Honor. Seated with us today at the table is Detective Florence from the Cleveland Police.
But on the Zoom. Do you know?
I believe that Ms. Cyrus's sister is also wanting to appear. She lives out of state.
Hold on, ma'am. I'm trying to do this. Oh, come on. It's really hard to do this up here, from up here. I saw that there was someone else trying to get in, but that person is gone. You want to call the sister?
We'll work on that, Your Honor.
Can you still hear me, ma'am?
Yes.
You can hear me?
I can barely.
Yeah, let me move my microphone. that better?
Yeah, that is so much better, thank you.
Okay, I'm sorry about that.
That's okay.
Was your sister trying to be part of the hearing?
She was trying to do that, so the internet is messing up at the moment.
Okay.
So,
All right, well, if I look up and I see her trying to get in again, I'll let her in. Are you okay? Are you okay going forward without her?
I am.
Okay, I'm ready.
Okay.
All right, we're moving on.
All right.
Mr. Bringman, on behalf of the state of Ohio.
Thank you, Your Honor. Your Honor, at this point, I take it that you, as you stated, you had a chance to review the pre-sentence report as well as the state of Ohio sentencing memorandum. Briefly, though, I do want to, I believe it is necessary to highlight to the court our concerns about this defendant's actions in the early days of May of this year. When you think about this case, the harm caused, the words that come to mind, I think are cruel, barbaric, and disturbing, to say the least. On May 2nd of this year, Cleveland police responded.
Are you sure it wasn't April 2nd?
May 2nd, Your Honor.
All right, so the PSI is wrong with regard to the date.
There was a typo in one of the police reports.
Okay, so they have it as Wednesday, April 3rd and Tuesday, April 2nd. Okay,
So at around 3 o'clock in the afternoon, First District officers received kind of a call to respond that a individual in the area had reported that she believed there was an individual a woman being tied up in the basement of the defendant's home. Officers responded just after 3 o'clock that evening. They made contact with Mr. Edmond-Geiger. Mr. Geiger refused to have them access the house. They were eventually able to give the consent to search his basement. They did a thorough search of his basement. They found, I believe, an air mattress, but nothing else. So with nothing else to go on, they left the house. They continued, though, to search for, kind of obtain any information based upon this initial call that came in. And they were able to speak with another individual, a female, who also reported the same thing to them, that there was a woman, specifically Miss Cyrus, being held, being tortured for the past several days in the defendant's house. Officers went back. They were able to gain access into the house and conduct a thorough search. And, Your Honor, this search, which was conducted by several First District police officers, was captured on their body camera. And I tried to summarize that as best I could in the report, in the memorandum. However, reviewing that body camera, it is disturbing. You can hear, as officers are trying to get any information at all from the defendant about the nature of why they're there, you can start to hear moans and groans from inside the house. And the officers begin to circle the house and call back to these sounds. And they are eventually, thanks in no part to this defendant, able to zero in on the front porch of the house. They're circling outside. They eventually make their way inside. When in that covered porch are a couple of plastic tool crates. They're maybe about 2 feet by 4 feet, 18 to 20 inches deep, I'd say. And on top of them is a heavy tool bag. They remove everything from on top, and they open it up, and they find Miss Cyrus folded up inside the crate. She's barely able to talk. Officers, to their credit, immediately called EMS. They did not want to. Her first words were, "I'm paralyzed, I'm paralyzed." EMS was called, and they were able to remove her from that crate. And, Your Honor, I think if I may approach.
you may.
From body camera as well as crime scene detectives who also immediately responded, they were able to document her location and condition at the time. And I would just show that to the court.
Need a
individually able to state A and B.
All right. Thank you. Okay.
And Your Honor, I mentioned that, they were able to locate her things in no part to the defendant. What is just as chilling when you review that body camera is that the moments, seconds before they're able to locate her, the defendant finally yells out, "She's in the tote," nonchalantly. He at that time showed no remorse for what he had done for her condition. What we came to learn during this investigation that she was there at 3 o'clock. I mentioned that they go, they get more information, they come back. I believe they come back around midnight, just after midnight. So that leads you to believe that either she was kept in that box that day alone for 8 hours, between 3 and 12, or he had removed her and put her back in there. And I don't know which one is more disturbing or cruel. Your Honor, the harm caused, I believe that Ms. Cyrus can speak to how his actions, how those few days have impacted her. Suffice it to say, she has undergone severe mental and physical suffering and harm. We were set for trial a few weeks ago. She would not have been able to be here without the assistance of medical transport. She is at this point 7 months later still in a long-term facility. She was transferred to Metro Hospital where she was treated for severe injuries. And speaking with the detective yesterday, I learned that, and I believe Ms. Cyrus can speak to this, that I think this past week or recently was the first time she was able to stand up. And that was with the assistant. So I'll let her speak to that more, but that's something that I was just made aware of. Your Honor, as outlined in our state's sentencing memorandum, we believe that these are on their face some of the most serious and worst forms of these offenses. We see these charges routinely, specifically kidnapping, but rarely do we see the type of torture and treatment and cruelty that Ms. Cyrus endured. And we believe that acts, the way these offenses were carried out, warrant maximum consecutive sentences. I understand and I've reviewed the mitigation and the pre-sentence reports, but I don't believe that, even taking all that into account, that it deserves any role in mitigating his conduct and the harm caused. So with that, Your Honor, I would ask the court to allow Ms. Cyrus to address the court and hear from her.
Okay. All right, Ms. Cyrus, can you still hear me?
Yes, Your Honor.
All right. Can you tell us what your first name is, please?
Cheryl,
And how do you spell that?
Cheryl.
Okay. And what would you like to say?
Okay. Your Honor, on approximately May 2nd, 2023, I became the victim of a horrific crime. A crime that included vicious beating, being held against my will, stabbed and having my arms tied. A TV broken over my head. He kicked me in the ribs, damaging them, which ultimately left my body. Once my neck was broken, I was picked up with a bear hug and trudged up and down stairs and from room to room. Eventually, this monster, without any sign of remorse, stuffed me in a 3x3 tote and closed the lid, which murdered my life as I knew. During all of this, I was threatened with a snitch and a rat, told it was my fault for his situation, not being able to see his daughter if he got caught. He is totally responsible for his actions, which now will keep him from his daughter. Going through all the pain he was inflicting, I was confused as to why he was doing this to me, as I have and never would snitch on anyone. Just the day before, I now recall feeling so independent, I walked a lot. I was happy, taking care of myself, enjoying life as I knew it, spending time with friends and embracing life. All that ended after this attack. I recall being found in a tote by police and telling them, I am paralyzed and I lose. I was in a coma for approximately 7 days, having had neck surgery and pulled through despite of his efforts to end my life, truly believing that was his plan. After being stabilized in paralyzation, I was transferred to a rehab facility to begin my new normal and remain there to this day. My life is impacted every moment in a negative way due to his anger, attack, and imaginary revenge on me. I experience painful muscle spasms and general pain every day. I am paralyzed and 98% dependent on others for my basic needs. I cannot walk. I cannot get myself out of bed, go to the bathroom, take a shower, dress myself, perform general hygiene, feed myself, smoke a cigarette, turn the TV channel, etc. I can only use 3 fingers on one hand and cannot use the other arm at all. I cannot stand, get out of bed or chair, or get to my feet without help and continuous assistance from others. All my normal things most humans can do without even thinking about it. I must wait until someone can help me. You lose a lot of dignity when you can't care for yourself and you feel like you are a burden to others. Since he committed these acts upon me, I have very few choices or control over my life due to my condition. I can't just jump in the car and take a walk beside what I'd like to eat, enjoy the sunshine, etc. I do try to keep in contact with loved ones. The days are long and can become very depressing. But I cannot use a cell phone without a struggle, especially answering a call or text. The highlight of my day now is waiting for staff to come and get me on the desk so I can go outside. Emotionally, I strive to stay positive and fight through the pain in hopes of regaining some movement and independence. I do suffer psychological issues due to my trauma and see a therapist and take medication for this. I am not able to give a proper hug physically to my loved ones, causing flashbacks of horrible pain as I was paralyzed. I can't have my door closed due to trauma of seeing the lid closing on a toe. I struggle to sleep and often lay awake for hours. I am much more tired now than before the attack. I love my family, but cannot just go visit them. I must wait until they can come and see me. All the burden is upon them now. I can no longer generate income and have become dependent on donations from others for my basic needs. My life has been reduced to 4 walls of my room until someone comes in so I can get out of my chair or into my chair. Spiritually, I know God lives and is with me and has saved me for a purpose. I await that purpose and remain open to His fire. That is one thing Geiger can never take from me is my faith. In closing, he may call it his house, but I call it the house of pain. The biggest fear is that he will do, I call it the house of pain. I will never be his victim because I believe he is a victim of himself. I'm also not a survivor, but I live through that and can continue to live. My biggest fear is that he will do this to someone else, someone not as strong or lucky as me, or either come after me in retaliation. I ask your honor to impose the maximum amount of time in his sentencing with no parole. I feel that he has earned it.
Thank you, ma'am.
You're welcome, Your Honor.
All right.
Thank you, Your Honor.
Okay, thank you. Mr. Radigan?
Thank you, Your Honor. Obviously, Your Honor, I'm not, anything I say here is not trying to be said to diminish what happened to this woman, and obviously what she went through was a horrible, horrible crime, and obviously the ramifications that she had are going to be long-lasting. I don't want to minimize that, Judge, but I'm not going to make excuses for Dalontay. We've spent a lot of time talking about what happened. Judge, he admitted to it when he was brought in. I know he gave a statement in his pre-sentence investigative report, so I'm not going to talk specifically about what was said there or why it was said and the other things that he indicated. But I do think, Judge, it's important, and I know the prosecutor indicated that mitigation isn't important here, but I do think it is. We can't explain or take away the horrific things that happened, but I think it's important, Judge, for us to realize and understand how we got to this point. Dalontay, as he sits here, is a damaged human being, and it's because of the way that he was brought up and the things that happened to him. Again, that doesn't make it better for what this poor woman has went through, but it explains how we got here, and I think that that is important. Judge, Dalontay was born in January of 1992, and the first time that Child and Family Services were involved in his life was 6 months later, in June of 1992. We were able to get some of the Child and Family Service records related to him, and most of them are so old that there's not a great detail as to what was going on. But what I can tell you is that June of 92, April 1st of 93, May 22nd of 95, July 26th of 95, January 22nd of 96, January 13th of 97, February 25th of 97, May 19th of 97, and February 17th of 1998. Those are all independent reports related to Child and Family Services intervention with the way that he was being raised. Judge, going further, there is not just the reports, but the findings of Child and Family Services. Going back to, I'll start in December 16th of 1999, there was a substantiated report of neglect against Dalontay and his brothers and sisters. December 21st, 1998, another report of physical abuse against him and his siblings. February 2nd of 1998, neglect again substantiated by Child and Family Services. May 18th of 1997, neglect substantiated by Child and Family Services. January 13th of 1997, neglect substantiated again by Child and Family Services. May 22nd of 1995, physical abuse indicated. July 6th of 1995, physical abuse indicated. May 18th of 1997, neglect, and that was in Pandora, Ohio, where he was in foster care. Another neglect substantiated by Child and Family Services. And then again, in January 28th of 1997, neglect that was substantiated again by Child and Family Services. Judge, this is kind of the path to how we got here. And unfortunately for him, when he was taken out of the family and received permanent custody from the county, it didn't get any better. He went to foster care. He was placed for the first time with another family with the county when he was 4 years old. He had 4 placements with regular beatings, abuse. There's reports that he was beat with weight belts, forced to drink alcohol before he was 10 years old. He was given drugs by certain members of foster families that he was with so that they could say that he had disabilities and they would receive more income from the county. This is the reality, Judge. This isn't made up. This is documented. Him and his brothers went through this together. They were split up at one point. Then they ended up in a county down in southern Ohio where the abuse continued. I not only have some of the records, Judge, but we were able to talk to some family members that tried to intervene and tried to get him out of the system and weren't able to do it. It was a tragic childhood for this guy. It really was, and I think it played a big role in what happened here. You can't go through that and come out undamaged without help, and I think that's what happened. Outside of that, Judge, he had an IEP when he was in school, did have some other issues that happened with that. To make matters worse, Judge, when I talked to his family members, and again, I'm not trying to minimize what happened, Judge, but there's a story behind it. There's a story behind how somebody can do what he did. And it is significant, and it does make a difference. After all that, he had his own business, he was running a car wash, and family members of the mother of his children came and robbed him at the car wash, stabbed him 8 times, shot him. He almost died, he almost bled out, somebody came, and that was in July of 2020. Judge, that left him in speaking with family members, some that are in the back of the courtroom here that don't want to be named, but that are here for him and have provided me with some information about Dalontay's childhood and what happened, said that changed him. It was, after that attack, he became a different human being. He became somebody that was capable of what Mr. Brinkman has talked about here. Prior to that, Judge, you can see his history is nothing like this. It's not, this wasn't somebody that was doing these things before this happened. There is a criminal history, Judge, but nothing like this. After that attack, he was diagnosed with PTSD, anxiety, depression, social distancing, nightmares, and flashbacks. Not only have family members said that, but there's some medical records related to that him indicating that this has changed him. This changed the way that he saw things and the way he did. This diagnosis of PTSD is not something made up, Judge. It's diagnosed. It was diagnosed by the court clinic in those reports and some medical records that we have as well. He's hypervigilant. Doctors say that his mental health issues were very deserving of treatment, is what the medical staff indicated when he was reviewed for competency. Just talking about some of those deep-rooted issues. Outside of all of that, Judge, we also had some medical records from Signature Health where he was linked up. And, you know, Judge, when I say somebody is damaged, it's sometimes there's the ability to fix it and change it. And I think that at least to some degree, Dalontay tried to do that. In January of this year, of 2023, he went to the hospital, he went to Signature Health to tell them that he was having nightmares, he was having flashbacks, and it was affecting the things that he did. He indicated to them there was some visions that he was having and some things that were affecting his ability to live day by day. He told the doctors at Signature Health that he was sleeping 2 to 3 hours a night, and he was really kind of spiraling out of control. And when they interviewed him, he said, and this is directly from the medical records, he said, "I feel like my mental health is getting bad." Says it's been bad since he was stabbed himself. He's afraid for his safety. He's always hypervigilant. A lot of people were relying on him. His anxiety was making it hard, and he was spiraling out of control. Unfortunately, there wasn't the medication that they gave him. He told the staff through the court clinic and other people that it wasn't working, it wasn't helping. And Judge, I don't know if that's ultimately what led to it, but I think even in the mitigation of penalty report that was provided, they indicated that some of these things certainly contributed to what happened this day. Again, Judge, this is the path of how we got here. This young man's childhood left him damaged, and I don't know that he's ever going to be undamaged, but I do think that it's significant when you impose a sentence here. He knows he has to go to prison. He knows it's going to be significant. But I do think that mitigation, Judge, can't be ignored. It can't be ignored of what, the start of this and how we got here. And certainly he has to go to prison, but I do think, Judge, that one sentence would be enough here. He will be on parole. He will have time hanging over his head with Reagan-Tokes. And if he doesn't get himself together and doesn't get the treatment in prison and he continues this behavior, they can keep him longer. But certainly, Judge, with somebody with this history, these mental health problems, this past, I don't think that consecutive maximum sentences are just or right. He's got to pay for his sins, and he will. But I do think that one sentence can certainly do that, Judge.
All right, thank you very much. Okay, Mr. Edmond-Geiger, would you like to say anything, sir?
Yeah, I would like to say I apologize to the victim and their family. I would also like to apologize to my kids and my family as well.
Okay, thank you, sir. All right, do a little bit of housekeeping first. Sir, when you're released from prison, you're going to be on post-release control for 2 to 5 years. Once you're released, if you violate the terms and conditions of that post-release control, you could go back to prison for up to 1/2 of the sentence that I imposed today. You could be charged with a felony called escape for failing to see your parole officer. They can make your supervision harder or longer for you. With regard to your probation violation cases. You are found to be in violation in case number 677-866 and 650-393. Your probation in those matters is terminated. With regard to your credit for time served, you've been in jail on case number 680-880 from May 3rd, 2023 to today's date, 11/30/23. You'll receive credit for those days that you served in jail. Sir, you are going to receive a sentence from Reagan Toke's sentence. We talked about that at your plea on count 4. The Department of Rehabilitation and Corrections may keep you incarcerated beyond the minimum term. I told you you're going to have to get a small number and a big number. Minimum term is the small number. They can keep you longer than the minimum term if they make specified findings rebutting the presumption of release. The Department of Rehabilitation and Corrections will have to hold a hearing pursuant to 2967.271 and find that one or more of the following 3 conditions apply. 1, regardless of your security level, if you violated institutional rules that compromise prison security. Did you want to say something else?
No, we're okay.
Or the safety of staff or inmates, or that involve physical harm or threat of physical harm to staff or inmates, and that those infractions demonstrate a lack of rehabilitation and the offender's behavior demonstrates that you continue to pose a threat to society. Two, you were placed in extended restrictive housing, that's the whole, at any time during the year preceding the hearing. And 3, if you're classified at a security level of 3 or higher. If the release presumption is rebutted, meaning they think you violated some of the rules I just went over, the DRC, Department of Rehabilitation and Corrections, may maintain your incarceration for a reasonable period as specified by the Department of Rehabilitation and Corrections, but it cannot exceed the larger number. The presumption of release applies to the additional period, if they oppose more time, by the DRC, and another hearing must be held to further extend the incarceration. You, however, must be released at the expiration of the maximum term and then will be subject to PRC, which we've already gone over. Your fines, fees, and costs will be waived. So the primary purposes and principles of sentencing are that I am to punish the offender and protect the public from future crime by the offender and others, using what the law says are minimum sanctions that the court determines accomplishes the purposes without imposing an unnecessary burden on state or local government resources. The primary principles are always to consider the need for incapacitation, deterrence, rehabilitation, and restitution. And the sentence should be commensurate with and not demeaning to the seriousness of the offender's conduct and its impact on the victim and consistent with sentences for similar crimes by similar offenders. In considering whether the offender's conduct is more serious, under 2929.12b, I have to consider whether the injury was exacerbated by the victim's physical or mental age or condition, which I do not find that it was. I do find that the victim suffered serious physical, psychological, and economic harm in this matter. I believe that the victim and the offender, did they have some type of friendship or relationship? They knew each other.
That's correct.
Okay. I do find that the offender's relationship with the victim facilitated the offense. I do not find any of the other considerations apply. In determining whether Mr. Edmond-Geiger's conduct is less serious, I do not find that the victim induced or facilitated the offense. I do not find that the offender acted under a strong provocation. I do not find that the offender did not cause or expect to cause physical harm to the persons, meaning the victim. I do not find that substantial grounds exist to mitigate Mr. Edmond-Geiger's conduct. Well, I find that there are substantial grounds to show how he got to the place he ended up at on May 2nd. And much of that is outlined in the court psychiatric clinic reports that I have, the pre-sentence report, and much more was outlined by Mr. Radigan when he spoke. I do not find that those mitigating factors constituted defense to the behavior that happened here. Whether recidivism is more likely, I do find that Mr. Edmond-Geiger was on community control when this happened. He does have a history of criminal convictions, though I will note that those convictions are not convictions of violence. Whether recidivism is less likely, I do not find he has any prior juvenile delinquency adjudications. He has one prior felony before these felonies in 2012. Everything else was misdemeanors. There could be an argument that he has not led a law-abiding life for a significant number of years. Whether the offense was committed under circumstances unlikely to reoccur, that is an unknown factor to the court. I do not know the answer to that. With regard to consecutive sentences, the presumption is that concurrent terms will be imposed with the discretion to impose consecutive sentences if necessary to protect the public or punish the offender, and not disproportionate, and the court has to make findings in order to do that. I am going to impose a consecutive sentence. The law wants the court to take into consideration similar crimes, similar offenses. I've never seen an offense like this in my time on the bench. I've had hundreds of kidnappings, probably hundreds of felonious assaults. Never have I seen anything to this magnitude. In fact, most of the kidnappings I think are just an extra charge that don't make much sense in the context of the cases that I've seen. This, in fact, indicates a kidnapping that truly is at the higher and more serious end of the spectrum, as well as the felonious assault. I do find that the victim suffered substantial and serious physical harm and mental harm. I find that these crimes were committed while Mr. Edmond-Geiger was under sanction. He was on probation with me. I do find that the harm in this matter is so great or unusual that a single term does not adequately reflect the seriousness of the conduct. Much of that has been outlined. I don't need to go over that again. It's been outlined by Mr. Bringman, and also with regard to the victim statement that she made in court. I make those two findings. Without this case, I could not find that he would have committed an offense of this nature. It is out of character for what he has had on his record. So I am going to impose a consecutive sentence with regard to counts 2 and 4. With regard to counts 5 and 6, the sentence on count 5 is 30 months. The sentence on count 6 is 30 months. Counts 5 and 6 will run concurrent to each other, and the sentences that were imposed in counts 5 and 6 will run concurrent to the sentences that are going to be imposed in counts 2 and 4. All right, count 2, 8 years. Count 4, 8 years is the minimum sentence to impose. 12 years is the maximum. Those counts are going to run consecutive. You have 16 years to 20 years to serve. He's ordered, remanded, and transported.
Jury just got off.
Okay, ma'am, thank you. I'm going to disconnect you now, okay?
Okay, thank you.
Yep.
Thanks, Josh.
All right, have a good day. Okay, Kevin?